Hearing in the matter of an application by Dennis Hutchings for judicial review.
Yes, Mr. Lewis.
May it please the Court, I appear for the appellant in this appeal along with Mr. Turkington. My learned friends Mr. Simpson and Mr. Shields appear for the respondent. My lady and my lords will have read the background to the appeal. The appellant, Corporal of Horse Hutchings, as he was in 1974, was the commander of a patrol in County Tyrone. In an instant, shots were fired and John Cunningham was fatally wounded. Public Prosecution Service in Northern Ireland have now, some 40 years later, charged him with attempted murder. This appeal concerns the Director of Public Prosecutions of Northern Ireland issuing a certificate that removed the appellant's right to trial by jury. There are two issues going to the Director's issuance of his certificate, namely procedural fairness and the true construction of Section 1, subsection 6 of the Justice and Security Act, Northern Ireland 2007. And subject to the Court's better view, I'd propose to deal with the procedural issue first, as it sets the context for my submissions on the second issue. And in fact, both we in our written case and my learned friends in their written case have adopted that procedure. May I then turn to the procedural issue and begin by introducing the legislative scheme. My lords, I noticed the copy which is in the electronic bundle may be slightly blurred, so I've asked and had put before the Court just a clean copy of the Act, which I hope is in slightly more legible form. For those using the electronic form, the legislative scheme, the Act, is set out in Appendix Part 1, page 203. And if we just look at the subsections, Section 1(2) is the operative subsection. It sets out the preconditions to the discretion arising, which are set out at subsection 1(2)(a) and b. And my lady and my lords will notice that A and B are conjunctive. Conditions 1 to 3 concern membership in or involvement of a prescribed organisation which has its activities connected with Northern Ireland. And we see the definition of prescribed organisation at subsection 10 of section 1, just over the page, if you're using the small clip. And you'll see that that limits the matters to be connected with the affairs of Northern Ireland. Condition 4 is not limited to the involvement with Northern Ireland. We find that at section 1, subsection 6. And subsections 7 and 8 supplement the definition in subsection 6. And just while I'm showing the Court the layout of the Act, I should just show the Court the ouster clause, which is at section 7. It's electronic page 207. That's section 7, which sets out the limitations on the challenge of issue of certificate. So, the first question is procedurally, should the Director's power to issue a certificate be exercised and how that procedure should occur? Now, the appellant says, at the minimum, he should be afforded an opportunity to make representations. If that is correct, then in order to make meaningful representations, at least the gist or the summary of the material the Director is considering should be disclosed. And finally, adequate reasons should be given. The respondent says, as the Court below held, that the ordinary rules of natural justice and procedural fairness are restricted in the exercise of this power. Can I begin in this way? It's our submission that it's clear law that the determination of procedural fairness is a matter for the Court and not for the decision maker. In case that's not accepted, may I just show my lady and my lords what Lord Justice Simon Brown, as he then was, said in the Pinochet litigation. It's volume 1, tab 14, page 649.
I wonder if this point is contentious.
No, I'm grateful. Yeah. I'll move on. So, of course, whilst we accept the statutory scheme as an important factor in determining procedural fairness, we do not accept, as the respondent submits, that Section 7 itself, the ouster clause, in the 2007 Act, is an indicator of what procedural fairness requires. Section 7 is dealing with challenges and seeks to restrict the jurisdiction of this court in those challenges. It does not inform the court of the requirements of procedural fairness. Indeed, the appellant's position is the antithesis of the respondent's. We say the more limited the review, the greater the transparency and procedural fairness that is required. It does not follow, as the respondent seems to submit, that Parliament, by attempting to restrict challenges on public law grounds, somehow intended to restrict the ambit of procedural fairness. We submit as a matter of common sense and logic, the opposite is true. Indeed, if the challenge is limited, procedural fairness needs to be heightened, not diminished. Put colloquially, Parliament did not intend to say that because you might get away with it and a departure from ordinary procedural fairness, owing to non-justiciability, there should be less procedural fairness. Now, the respondent places heavy reliance in this matter on the analogy of the decision of the director issuing a certificate under the 2007 Act with a decision to prosecute. It's our submission that that analogy is misplaced. Can I show my lords first and my lady, first the case of Kebeline, to what Lord Stayne said. It's in volume 1, tab 10, page 505 in London. And if I go direct to what the respondent relies upon, the court will find it at page 550, letter F. And if I just pick it up, just below F, these are the words which are quoted in my learned friend's case, and indeed by the court below. My lords, I would rule that absent dishonesty or mala fides, or an exceptional circumstance, the decision of the director to consent to the prosecution of the applicants is not amenable to judicial review. Now, with that, we take no issue. Importantly, Lord Stayne was careful with his words, and the restriction put on review was limited to decisions to consent to a prosecution. The essential principle that underlies that ruling is that there is an alternative remedy. Namely, the challenge should be taken in the trial process itself. If we go back to bundle page 548...
Just before we leave this, it rather looks as though the draftsman may have had Lord Stayne's speech in front of him.
My Lord,
absent dishonesty, mala fides, or an exceptional circumstance. And then one looks at section 7.1, dishonesty, bad faith, or other exceptional circumstances.
My Lord, that's right. It's been a traditional approach of decisions to prosecute.
Yes, but I think my Lord's point is that the respondent's argument, the analogy is apt, may be fortified by the circumstance that the words used by Lord Stayne have been repeated in Section 7.
My Lord, those words are repeated in many, many cases. But the important point, as I will explain to my lords and my lady in a moment, is that the principle behind it only occurs where there is an alternative remedy, and that is strongly shown. Can I just show, develop this point? If we go back to page 548, and we pick it up at D, there is a submission by Mr. Panic, as he then was, relating to section 29.3. And the court will know that section 29.3 of the Senior Courts Act prevents challenges by way of judicial review to matters relating to trial on indictment. So what Mr. Panic was saying was that there was also a common law principle which had exactly the same approach. If we drop down just below E to F, you'll see that Lord Stone says he doesn't wish to base his decision on those observations. And the words there used are exactly the same. Just to pick up the point from my Lord Reid, you'll see that between D and E, the common law principle, absent dishonesty, malefides, or some other wholly exceptional circumstance, they also echo in, one could say, section 7. It's simply a principle. But if I pick it up, then going down to F, where Lord Stay says, that is, however, a wholly different situation, because in such a case there is no other remedy, where he's dealing with decisions not to prosecute. So there is a material distinction between decisions to prosecute and decisions not to prosecute. I won't read them out, but my lords will see, he also says that's force, this is at H on page 548, to the policy underlying the statute. You wouldn't have a collateral challenge to matters which could be raised in the, which could not be raised by way of judicial review under section 29.3. Now, if we go to what Lord Cook says at page 551, he echoes the principle which is of alternative remedy. And if we pick that up between E and F, but in a case where it's obvious the director wishes a charge to go to trial, I think the court should be very slow to allow review of a consent to be used as a device for resolving points which would otherwise be dealt with in the ordinary course of the criminal proceedings. So again, the emphasis on alternative remedy. And indeed, if we see Lord Hope accepts the reasoning at 555C, I needn't take you to that, he simply adopts it, and Lord Hobhouse makes the same point at 572C. Just picking that up at 572, it's report page 393 in the speech of Lord Hobhouse. Another, between B and C, another is the refusal of judicial review where other legal remedies are available. Now that position is echoed in all the authorities. And if I take you to the one which, in fact, my learned friend relies upon, which is the decision of the Judicial Committee, we can see what the board says in the case of Sharma. My lords, that's in volume 3, tab 32, page 1293, bundle page 1293. The board gave its opinion in two tranches. The first by Lords Bingham and Walker. And if we turn to page 1301, we see that between D and E, decisions have been successfully challenged where the decision is not to prosecute. In such a case, the aggrieved person cannot raise his or her complaint in a criminal trial or on appeal, and judicial review affords the only possible remedy. And again, it's picked up, if we go between G and H in Roman 4, the reliance on Kebelin and Papulski. The remaining members of the board echo that approach, And if we pick up what Baroness Hale, Lord Carswell and Lord Mance said, it begins at 1307, paragraph 31. Paragraph 31, the possibility of a challenge to the prosecutorial decision and the apparent inevitability of full investigation in the course of any criminal proceedings into the background of the decision to prosecute are, in our view, features central to the resolution of the present appeal. They could properly be raised in the criminal proceedings, either in the course of an application to stay those proceedings or on the grounds of abuse of process or in any substantive trial. Like Lord Bingham and Lord Walker, we are not persuaded the Chief Justice's complaint could not properly be resolved within the criminal process. And if we go over the page at 1308, paragraph 34, viewing the matter generally, the present is clearly a case where all issues should, if possible, be resolved in one set of proceedings. And it echoes what they say. We see the approach of Lord Steyne and Kebelin between F and G. So we submit the common thread running through all the authorities is the reluctance to challenge a decision to prosecute is because there is an alternative remedy available in the trial process itself. Now, if that is the correct principle, and we say it's really indisputable that that is not the correct principle, in the issuance of a certificate under Section 1 of the 2007 Act, there is no scope whatsoever for it to be dealt with or reviewed by the trial judge. That, I'm sure, will be common ground. Section 5 of the 2000 Act states that once the certificate is issued, the trial will be by judge alone. I don't see that. It's 5.1, the effect of a certificate issued under Section 1 is the trial or indictment of, is to be conducted without a jury. So there is a fundamental distinction in the exercise of the principle which underlie the decision of the director to consent to prosecute. That is an alternative remedy. That does not apply in the issuance of a certificate, and that is a fundamental distinction. And we do say that the view of the divisional court in Arthur's application, which I'll take my lady and my lords to in due course, is based on an erroneous understanding of the principle underlying the reviewability of prosecutorial decisions.
Can I just raise a matter with you, which I hope you'll deal with at some point? It's clear from the legislation that the fact that a certificate has been issued is not conclusive, because under Section 2, the certificate can be modified or withdrawn, and under Section 3, there can be a preliminary inquiry into the offence if the prosecution so requests. And one might think the object of the preliminary inquiry would be to obtain more information which might bear on the appropriateness of the certificate.
Lord, with respect, we don't think that's a proper reading of this. Section 2.
It's just at some point, your submissions so far are focusing on procedure prior to the issue of the certificate. We need at some stage to address what might be done after it's been issued.
I'm happy to deal with it now. Certificates under Section 2 simply say that it must be lodged before arrangement, and it can be modified or withdrawn subsection 2 at any time before arraignment. Once the defendant has been arraigned, that is the end of it. They are not open to challenge. Section 3, the preliminary inquiry, which is really committal proceedings, in our respectful submission has nothing whatsoever to do with the issuance of a certificate. what this does is allow a preliminary inquiry under the Magistrates' Court Act, i.e. a committal, to proceed without calling live witnesses in order to give depositions. So when a certificate has been issued, it is a safety measure, as it were, for those reasons, in order to conduct the preliminary inquiry in certain circumstances. In our respectful submission, and we'll hear what Mr. Simpson has to say about it, but we would say Section 3 has nothing whatsoever to do with any further procedure in relating to the challenge of the certificate. Perhaps I can just take you then to Arthur's application where this principle was applied. It's in Volume 1, Tab 1, page 269. At paragraph 25. That's page 279 of the bundle. My lady and my lords will appreciate that this is an application concerning the issuance of a certificate under the 2007 Act. It is in fact relating to Condition 1, not Condition 4, and it's a decision of the Divisional Court in Northern Ireland. If we pick it up at 25, which is 279, they deal with the procedural fairness point. And at 25, in its reasoning, and they're referring back to the case of Shuka, the court was heavily influenced by the well-established limitations on the review of prosecutorial decisions, when in fact that should strictly be said, decisions to prosecute, by the DPP emerging from the authorities. They set out, and they quote from the case of Sharma, which I've already showed my lady and my lords. And you'll see over the page at 280, the precise quotation which is relied upon from Lord Stane, which I showed the court from Keberling. And it picks up the point which my Lord already put to me. It's apparent the statutory language in Section 7 is inspired by the principle of exceptionality applicable in the context of prosecutorial decisions. But in fact, we would say when carefully analysed, the principle only applies where it is consent to prosecute and there is an alternative remedy. So, we do say that what the court in Arthur's application did was it aligns the decision to prosecute with the decision to issue a certificate under the 2007 Act, and then applies the reasoning to procedural fairness. We say that that reasoning contains a flawed syllogism. Decisions to prosecute are almost unreviewable. Decisions to issue a certificate are prosecutorial decisions. Therefore, decisions to issue a certificate are almost unreviewable. It's a flawed logic. The flaw is aligning, in the case there, a decision to prosecute with a decision to issue a certificate. And we deal with this in some depth at paragraph 19 of our written case. And if I can just bring that to my Lord's attention, to explain why we say they are fundamentally different decisions. If we pick it up at paragraph 19, it's bundled page 45. And we set out a number of reasons why the decision to prosecute and the decision to issue a certificate are not analogous, and it would be wrong to align them. The first, at 19, the decision to remove the right to trial by jury is not equivalent, as we set out, because in taking a decision to prosecute, there is no right not to be prosecuted. unlike the situation, there is in fact a right to be tried by jury. As was pointed out in the case of the Crown and Tomey, trial by jury is a right. We set out the previous quote rather than just trespassing on the court's patience by picking it up. It's paragraph 15 on page 44, just opposite. You can see where we quote from Lord Chief Justice, paragraph 10. In this country, trial by jury is a hallowed principle of the administration of criminal justice. It's properly identified as a right available to be exercised by a defendant unless until the right is amended or circumscribed by express legislation. So, that is the first fundamental distinction. Secondly, a person facing a decision to charge has not at that point had the legal machinery instigated against him. In a decision to remove the right to trial by jury, the person has already been charged and is under the jurisdiction of the court. As I've shown the court, the defendant has a fundamental right to trial by jury, which the opposing party in the prosecution, the Director of Public Prosecutions, unilaterally changes without recourse to the court. And the court will just see from the footnote, just so you understand the dates, he was charged on the 24th of April 2005 and appeared before the Omar Magistrates Court on the 25th of April, the next day, 2005. The certificate was applied for by the Public Prosecution Service and issued in April 2016. So a year later, he, the director, makes the decision to issue the certificate.
That, of course, would have been before arraignment.
My lord, that's correct.
Yes. So the opportunity to modify existed up until the date of arraignment. Do we have the date of arraignment, any chance?
My lord, I'm reasonably confident because of the dicta in at the end of Arthur's case. I made a submission to the Crown Court judge that he should not be arraigned in case the certificate is changed.
Right.
And in those circumstances, I don't think he's yet been arraigned.
He hasn't yet been
correct.
arraigned.
And
I
because
see.
there was some criticism in Arthur's case that there was nothing the court could do because arraignment had taken place and therefore the statute stopped.
Right. So in effect, Section 2, subsection 2, still is available?
Yes.
Yes. Thank you.
Thirdly, just working through our points on paragraph 19 of our written case. Before a decision to prosecute is made, the prosecutor will have given the putative defendant the opportunity on arrest by way of caution or on interview by way of caution of questioning to making representations as why he shouldn't be charged. This is contrasted with the present situation of not allowing representations before making a decision to issue the certificate under the 2007 Act. Fourthly, as we say, the decision taken by the respondent is statutory. A decision to prosecute is non-statutory. And fifthly, the difficult area of public interest is evaluated by the prosecutor when deciding to charge. There is no public interest component to the issuance of a certificate under the 2007 Act.
Well, first of all, could I ask you what is the significance of the fourth factor, that the decision is statutory, whereas the decision to prosecute is non-statutory?
Because generally speaking, judicial review, my lord, where you have a statutory decision, it's more amenable than a common law discretion. The discretion to prosecute is only, according to the authorities, amenable to judicial review in cases of
I see. So you say that it should be more readily amenable in this instance to judicial review?
because it's a statutory
Yes, I see.
decision, and Parliament has set out a statutory provision for it.
And why do you say that there is no public interest
My Lord, for
in
this
the issuance
reason,
of a certificate?
in a decision to prosecute, the prosecutor will normally use the general code, which is there a evidential test, is there a reasonable prospect of conviction, and then a public interest test. Is it in the public interest to prosecute? And there are many factors I can understand which inform that second part of the decision. However, when we're dealing with a purely statutory test here, subsection 1(2) simply has two statutory preconditions. And the preconditions are, does it fall within condition 4? And then secondly, with a view to that, is it likely to interfere with the administration of justice? That is not.
Is there no public interest dimension to the second of those?
My Lord, no, because it would be difficult to say that if it did interfere with the administration of justice, you could not issue the certificate. Because the administration of justice here is based upon, particularly based upon factors such as, said by the director, a biased jury, other factors which would be jury tampering. Insofar as there might be some public interest in that, it's of a entirely
It's of a different nature,
scale.
yeah, yes.
It's a different scale.
But I think it's slightly ambitious to say that there is no public interest at
My
all.
Lord, I accept that. I mean, but it's a much more limited compass
Yes, I see.
and informed in those positions. Indeed, as we'll see in the debates in Parliament, no example could ever be given when, if it fulfilled the statutory conditions, that a certificate would not be issued. So, finally, a decision to prosecute is a procedural step which simply sets in motion machinery for adjudication. It's not adjudicatory of rights. That is a decision to prosecute. It sets in motion proceedings to decide rights. The decision to remove the fundamental right of a jury trial is itself adjudicatory. And the respondent makes it plain he's acting in an adjudicatory capacity as he only issues his certificate upon application. Can I just make that good? If we've got the core bundle there, it's Appendix Part 1, page 193, at paragraph 16. And you will see that in his affidavit, the director volunteers that the last sentence in paragraph 16, I confirm that my decision to issue a certificate is a decision I take on a case-by-case basis and only upon adjudication. So,
Upon application.
upon application, upon application, page 193. Paragraph 16. Does my lord have it?
Yes, yes. I was just querying your use of the word adjudication. I think it's
Yes,
upon application.
I misspoke.
That's all right.
And he's referring to application by whom?
My understanding, and I think I can take you to, we have no evidence of this because we were given no details of the procedure and we were not given any disclosure. But it's interesting to note in Arthur's case, I think that if we just pick that up, just to show my lord, to answer the question, if we went to volume 1, tab 1, page 273, what appears to be the procedure is set out there. Volume 1, tab 1, 273. There's a subheading, background to the director's certificate. Paragraph 9, it begins with Stephen Heron, a senior public prosecutor in the Public Prosecution Service. And at paragraph 10, what happens is that the police view was taking account of the views of senior investigating officers and intelligence held by the police. Conditions in 1 and 2 in Section 1, 3 and 4 of the 2007 Act. That was whether or not you were a member of a prescribed organisation. Intelligence was considered reliable by police and was available for inspection by Mr. Heron and duly inspected. Mr. Heron prepared a report for the Director in consultation with senior colleagues, and he conducted an internal search of the media reporting relating to the applicant Brian Arthurs generally. His report to the Director also drew attention to the report of the Internal Monitoring Commission. So the best I can do to answer my Lord's question is it appears that a senior lawyer at the Public Prosecution Service prepares a brief,
Yes.
and the Director treats that as an application to him in order for him to consider exercising his discretion under Section 1 of the Act.
Yes, but that's stimulated, is it, by a report by a senior police officer?
Apparently so, my
Yeah.
Lord. So, and that, of course, is an extremely, if we just step back from a moment, we're not dealing with a decision to prosecute where no proceedings have been instituted and the court is not involved. Here, the court is engaged, is meant to be supervising the position, and an application is made effectively to the prosecution, by the prosecution, to the head of the prosecution, and a certificate altering the procedures within the trial process itself, with no recourse to the court, is made. So we do say, as we say in our written case, the respondent, having set himself up as a quasi-judicial decision maker, the application of one party creates a duty to hear the opposing party before making the decision. And if a respondent is to act impartially, the entire process must be fair, transparent, and independent of the prosecution. And Lords, having shown the material distinctions between a decision to prosecute and a decision under the 2007 Act, it's important to contrast it perhaps with the descheduling which occurred prior to the 2007 Act under originally the Emergency Powers legislation and then subsequently Part 7 of the Terrorism Act 2000. Both those pieces of legislation effectively said there are a number of offences which will be tried without a jury. However, there was a caveat within the schedule which allowed the Attorney General to deschedule the offence, saying it could be tried with a jury. Now, the Attorney General's policy, his published policy, was that he would only deschedule offences if they were not connected with the emergency. Now, this was swept away by the 2007 Act. And the scheme which we have seen under Section 1 of that Act imposed. But importantly, and this is a crucial point we would respectfully say, under the descheduling process, the defendant was given the opportunity of making representations. So if we can see that in the case, I know my Lord Kerr dealt with Re Shuka. If we go to Re Shuka, it's Volume 1, Tab 16, page 723. So this was an application in relation to the previous scheme. This was the descheduling by the Attorney General. And if we pick it up at paragraph 28, page 733, at paragraph 28, and if I just drop down to the final full sentence in paragraph 28, just above D, on page 733, in the present cases, the applicants were able, through their solicitors, to make representations on why they believed that the offences with which they were charged had no connection with the emergency, and those representations were considered before the decision not to deschedule was taken place. So the previous system allowed representations to be made. And indeed, the fairness of making representations was set out in a government statement, which in itself can be described as a policy or a promise creating a legitimate expectation. Can I show my lords that? It's in volume 2, tab 28, page 1073. Just to introduce it, at the beginning of tab 28, we have the House of Lords, House of Commons Joint Committee on Human Rights, Legislative Scrutiny, third process report, and it was published. So this is a published report. Do my lords have that? It begins at 1063. But while I want to take... Sorry, my lord?
1063.
1063 it begins. I want to take my lords to 1073. And if we pick...
This is the legislative scrutiny of the bill that became
exactly,
the 2007.
But I'm going to show, my lords, the answer by the Secretary of State. So what happens? We see at 1073, we've got width of the DP powers to certify. And if we go over the page to 1074, at paragraph 1.24, the committee said, we also asked the government what safeguards there would be against this extremely broad power being exercised arbitrarily. 1.25, the government in its response states the decision is one of mode of trial only, decisions which the DPT already takes when deciding whether certain offences should be tried summarily or an indictment, and that the defendant will still be able to make representations to the DPP about the mode of trial decision. It drops down, final sentence, the government is satisfied these safeguards provide adequate protection. And we can actually see the letter itself sent to the committee, which is published at page 1121. It's entitled Appendix 1D, letter dated the 22nd of January 2007, from Paul Goggins, Parliamentary Undersecretary of State. And you'll see that the Undersecretary says the Secretary of State has asked him to reply. So this is a copy of the letter which is sent back and published. And the question I drew the court's attention to was question 3, and the Undersecretary of State deals with question 3 at page 1124. Question 3, what safeguards are contemplated to guard against the risk of the power being abused? And the statement is, the DPP's direction is one of mode of trial only. I'll come back to the moment, but we just simply say that's erroneous. The DPP in Northern Ireland already makes such decisions. For example, whether certain offences should be tried summarily before a magistrate or indictment in the Crown Court. As is the case at present, the defendant will be able to make representations to the DPP about the mode of trial decision. The DPP can take those into account before his decision-making, or can vary his decision at a later stage on the foot of the representations received. So there, we do say, is a clear, unambiguous promise, devoid of relevant qualification. My lords will notice the way I put that. It falls directly as a legitimate expectation or promise or policy promise. And as such, published in that way, it creates a legitimate expectation, a procedural.
A legitimate expectation to what end? Legitimate expectation is surely the ability to make representations. That's the undertaking that has been given,
Yes.
if indeed it qualifies.
It's denied in this case, Mike.
It has been denied that...
Can I take you to the Statement of Facts and Issues? If one goes to Statement of Facts and Issues, paragraph 12, one sees that at page 35 in the Statement of Issues, issuance of the certificate. My lords have that, it's in the main bundle.
Yes, I've read that. But surely the answer from Mr. Goggins was to the effect that after the decision to issue the certificate has been made, the opportunity would be available to make representations.
My Lord, no. I think that would be a misreading. This is particularly what is said, the opportunity before he can issue the certificate. It's in line with the procedure under Re-Shuka and in line with the procedure that was in place before the descheduling by the Attorney General. So there always was a procedure to make representations.
But in fact, your client has had the opportunity to make representations and at a time when the certificate can be withdrawn.
My Lord, no, we respectfully say the certificate was issued.
Yes, but
I
I thought you told us that your client has not yet been arraigned, and so the power to withdraw the certificate under Section 2.2 remains on foot. And
My Lord,
I was putting to you,
my Lord, that
is it not the case that
in
your
theory,
client has had
one could
the opportunity to make
one
representations?
could ask the director to remake his decision. Application for review is under challenge, is the decision to issue. And it would be strange, we would say, if you would have to wait till the director issued his certificate and he refuses to give you any material upon which he made that decision. And we say manifestly inadequate reasons. If you could then challenge, we did.
Sorry to interrupt. I thought you were saying to us that in this letter, a clear and unequivocal representation had been made on which you rely for a legitimate expectation.
Yes.
But is it not the case that, in fact, the representation that is made contemplates that it may be that representation is made after the certificate?
I see my Lord's point. Yes, I accept that.
So does that mean that your legitimate expectation point falls away?
Well, my Lord, I wouldn't like to readily admit it falls away at the moment, but I see the force in my Lord's point that we could make subsequent representations now because he hasn't been arraigned. But of course, the decision under challenge was the original decision to issue.
Definitely.
And of course, the procedure before was that representations were allowed prior to the decision being made. If the relevant qualification is by the Under-Secretary of State that he can vary his decision at a later stage on the foot, we say that that is not a procedurally fair matter. You should be entitled to make the decision.
Yes, sorry, I wasn't suggesting it was the end of your case.
No.
I was just looking to see whether you can, in fact, maintain a viable legitimate expectation case. That's what I was looking for assistance with.
It may be misleading, but Lord Justice Gillen, in giving the judgment of the Divisional Court at page 346, recorded that one of the arguments that had originally been put forward, this is paragraph 5, was that the decision was in breach of the legitimate expectation of the applicant that the director would conduct a rigorous scrutiny. Now, I acknowledge immediately that's a different species of legitimate expectation, but he continues the concept of legitimate expectation was not pursued by Mr. Lewis at the hearing before this court.
Oh, that's right. And I confess that I hadn't put before the court, I hadn't seen the letter from Paul Goggins at that stage. So the letter from Paul Goggins was not before the Divisional Court.
So it's a different type of legitimate expectation.
It is.
That you can.
Because what we're talking, as your lordships are fully aware, my lady is fully aware, is a procedural legitimate expectation.
Yes.
Now, we do say...
And you say that the statement made by the government minister promoting the bill creates a legitimate expectation as against the independent DPP.
Well, certainly, I see what my Lord's point, because, of course, the separation of powers and dealing with separation of powers, independent decision maker.
Yeah.
But, of course, he's acting in a quasi-adjudicatory manner here, the director. If I can't rely upon it as a legitimate expectation, I can simply rely upon it in that it demolishes, in my respectful submission, the submissions which were made and will be made, that, of course, these type of matters don't require representations because they're sensitive and they involve matters of security, and that this is not an area where the courts should tread. So insofar as it advances my general argument as a matter of ordinary fairness that applies, I perhaps don't need to go as far as to say that there is a procedural legitimate expectation created by this.
Yes, I mean, the difficulty is obviously the minister is providing information to the parliamentary committee as to what he understands to be the effect of the legislation he's promoting. But he is never going to be the person making the decisions under the legislation.
Yes. So perhaps my better position is to pray generally in aid that it's a mistake to say that we would go as far as to say that the statement effectively pulls the rug from the respondent's submission, that it's impractical or unnecessary, or would disclose sensitive information if such an opportunity was afforded in the small number of cases to which the 2007 Act applies. And it also, we would respectfully say, undermines the reasoning in Arthur's application. If I could just take you back to that, because it is a point we make in our written submissions. Again, it's volume 1, tab 1, page 269. There is, if I can describe it as an interesting passage, at paragraph 33 on page 284. Can I just pick it up halfway through paragraph 33? What the court there say, this is 284, about 15 lines up, after dealing with Re-Shuka, it says, a suspicion once formed on the basis of sensitive intelligent material, usually of such a nature that it could not in the public interest be disclosed to the defendant, will remain unless it can be wholly dispelled. The ipse dixit of the defendant denying any ground for suspicion is not going to dispel a suspicion properly formed on the basis of intelligence advice emanating from apparently reliable sources. The nature of the exercise to be carried out by the director does not, as pointed out in Re-Shuka, lend itself either to the full panoply of judicial review or the implication of a duty to seek or receive representations before the director forms a suspicion. And my Lord, it is respectfully submitted that the reasoning of the divisional court there is misconceived, because it amounts to this. Because the director will have formed a suspicion on material before him, any representations made by the defendant will be otiose. So there's no point in allowing the defendant to make representations. So we regret to say that approach is almost Kafkaesque. And it's certainly at odds with the way in which it was dealt with by receiving representations and what the minister has said. It effectively becomes this from the director issuing a certificate: a secret determination on material you're not able to see or test without the opportunity of challenging, commenting or making representations. We say that's just a breach of natural justice and procedural fairness. And I also just need to deal with the point, my Lords will have seen that in the letter from the Parliamentary Under-Secretary of State, he talked about it being mode of trial only, and therefore the director makes mode of trial decisions. We respectfully say that that is in fact a disingenuous argument. the small number of exceptional cases to which application for a certificate will be made will inevitably be indictable-only offences. The director has no input or decision-making powers in relation to mode of trial for indictable-only offences. Indeed, he doesn't have for triable either way offences where the defendant can elect trial on indictment. It is fanciful to say it might be because he can proffer a charge which is triable only summarily with 6 months or 1 year imprisonment, that is equatable to the decision in the instant case. Could I then just pick up our written case at paragraph 31, page 48 of the bundle?
Sorry, page.
I'm sorry, my lord, it's page 48
Thank
of
you.
The core bundle. Paragraph, I was going to take you to paragraph 31.
Thank you.
It's one of the responses, both made by the court below and by the respondent in his answer to our written case, is that the respondent takes into account matters of impression and sensitive information. We say that is no answer to deny an opportunity to make representations and for the court to scrutinise his decision. And it's clear that the decision of the director is not simply one of discretion. There are statutory preconditions which must be fulfilled before his discretion can arise. It follows the test is not arbitrary. He must be satisfied of the statutory conditions. And the courts have often and continue to be arbiters of whether a decision maker's suspicion is reasonable, such as a police officer, whether or not a police officer has a reasonable suspicion. My learned friend makes point of the fact there's a lack of the word reasonable in the statute. We say that's nothing to the point. The director cannot lawfully hold an unreasonable suspicion. And I'll be interested to hear my learned friend say otherwise. In Re Shuka, which I know my Lord Kerr presided, the court held that the scheduling discretion was a procedure on which the court should be reluctant to intrude. Now, whether or not that is still good law is nothing for the point on this appeal, where we have a statutory test with preconditions. But the question of depriving a person of a jury trial is an issue on which the courts have been enjoined to decide on an inter-party basis, certainly under the 2003 Act. I can show my lords that. It's section 44 of the 2003 Criminal Justice Act. It's in volume 2, tab 25. Page 1013. 1013. Now, this is a provision which applies throughout the United Kingdom and Northern Ireland. And one will immediately see the similarities set out under section 44, subsection 2. The prosecution may apply to a judge of the Crown Court for the trial to be conducted without a jury. In the instant case, by analogy, it's simply the prosecution apply to the director for the trial to be conducted without a jury. And if one goes over the page, section 45 on page 1015, there is express provision under section 45, subsection 3, for the defendant to be given an opportunity to make representations with respect to the application. So this is on jury tampering. And the point I'm perhaps inelegantly trying to make is that the reasoning put forward in Re Shuka that courts are reluctant to intrude upon the decision-making power, such as descheduling or determining the right to trial by jury. It doesn't hold good when there is, in fact, an example of a precise statutory power enjoining the courts to intrude upon that area. So, by parity of reasoning, we say it's difficult, if not impossible, to sustain that part of the reasoning in Reshuka in applying the decision to hold a trial without a jury as grounds on which the courts must, on principle, be reluctant to tread. Returning to our written case, in paragraphs 35 to 36, we make concluding points on the procedural fairness points. And it really comes to this. We do say, stepping back and looking at the position in the round, there is simply no sustainable reason to allow the prosecutor, after proceedings have commenced, to determine in secret that a fundamental procedural right of the appellant will be taken away without allowing the appellant an opportunity to make representations on it. So that deals with the representations point. Well, moving then to the adequacy of reasons. The decision letter is at the core bundle, Appendix Part 1, page 157, tab 8. Page 157, it's paragraph. It doesn't actually have tabs. I'm sorry, my lord. It's core bundle, page 157. It's a letter from the Public Prosecution Service dated the 10th of May. Do my lords and my lady have it? This is the decision letter. Now, we see in paragraph 2 that the decision letter says the director was satisfied on information provided by the police and the advice of senior counsel. Now, that information is not explained or disclosed. Paragraph 3 identifies the risk of being that of a biased juror or jury. No further reasoning is added. My lord, see that's the last sentence on paragraph 3 of the decision letter. Interestingly, if we then pick it up on paragraph 4, there is a strange and irrelevant reference to mitigating the risk of the possibility of a biased juror by screening or sequestration. It's obvious that those considerations are irrelevant to a biased juror. You can't prevent a biased juror by sequestering him or screening. There is no mention, interestingly, in the decision letter of the change in random jury selection brought in by the 2007 Act. My lords have that up, section 13. I won't take you to it, but section 13 of the Act prevents preemptory challenges. The court will probably be aware there was some suspicion that it was a way of packing the jury by preemptory. So that was taken away. But in addition to that, and importantly, the Attorney General published guidelines on enhanced vetting for jurors. We in fact have those. If my lords want to glance at them, they're in volume 2 of the authorities, tab 25, page 1134. Did I say it's 1134? It's not tab 25, it's tab 28. They begin at 1134, and my lords could just see those. I won't spend any time on them, but you'll see specific guidelines were set out to deal specifically with biased jurors. And if you just go over the page to 1135 and just pick it up at paragraph 2, it's number 2 on page 1135. Parliament has provided safeguards against jurors who may be corrupt or biased, provision for majority verdicts, and at 3, certain exceptional types of cases of public importance, which the provision of majority verdicts and the disqualification of jurors may not be sufficient to ensure the proper administration of justice. And there they set out, if we go over the page, you'll see at the top there are enhanced jury checks. I only point that out because it doesn't appear in the decision letter that any consideration whatsoever was given to those 2 important factors. Going back to the decision letter, which we had at page 157, if we just look at the last, just go page, it's fairly short. At page 158, we simply see the bold statement at the top of page 158. In reaching his decision, the director had regard to the views of police, analysis of the circumstances of his case, and evidence to be led at the trial of the advice of senior counsel. But we have no details of that at all. In fact, none of that was elaborated or disclosed. In the pre-action protocol letter we issued on behalf of the appellant on receipt of the decision letter, we asked for that. My lords will see that. The pre-action protocol letter begins at page 159 of the bundle, and at 164 you will see set out what was requested at subparagraphs 1, 2 and 3. Full and adequate reasons, further disclosure, and revocation of the decision to issue the certificate. The answer to that was that there was to be no further disclosure and no information given. To some extent, the reasons were elaborated upon in the reply to the pre-action protocol letter, but in fact they are identical to the reasons given in the second in the affidavit of Barra Magori, which I should show the court. So, if we go to his affidavit, which was before the court, page 191 of the bundle, this is in response to the permission granted for judicial review. And we see at dealing with this point, you'll see at paragraph 8, page 192, what he says is, paragraph 7, he sets out what condition 4 requires. At 8, I respectfully contend the wording suggests it was the intention of Parliament to provide that this subsection should be broadly interpreted. Now, we take issue with that in any event because there's direct authority that it should be narrowly construed. And at 10, we have what we say is the sum of the reasoning of the director, why condition 4 was engaged. And one sees, I'll come back to that in due course, but I simply ask the court at this stage to note that paragraph 10 is little more than a recitation of the statutory words of section 1, subsection 6. Paragraph 14, he deals with the second limb of section 1, 2. And while we have had reference to the affidavit of the respondent, we do say in our primary submission that the adequacy of reasons should be tested against the decision letter to avoid any suspicion of subsequent rationalisation. Now, I'm conscious of the time, and our submissions on the adequacy of reasons are fully set out in our written case, paragraphs 39 to 49, and my lords will be familiar of what reasons are required. And in short, we say what was given in the decision letter, and indeed in the affidavit, are just simply manifestly inadequate. The third head of procedural fairness, again, I can take this quite quickly.
Sorry, just on the reasons, is it right that we also have regard to the Public Prosecution Service letter and reply to the pre-action protocol?
I'm happy for my lord too. It's in identical terms to the affidavit. In fact, it's word perfect. It looks like a cut and paste job. So the affidavit is the same as the PAP letter,
Yes, thank you.
the reply to the PAP letter. So my lord, final head, failure to provide materials on which the decision was based. Obviously, this only applies if your lordships find favour with my submission that there was a duty to allow representations to be made. The court has seen that we asked for the materials in the pre-action protocol letter. They were not forthcoming, and no reasons were given for the refusal of those documents. We wrote once again, once permission had been granted, and asked for the material based upon the evidence set out in the affidavit in answer of the director. Can I just show my lords that? If we go to page 200 in the bundle, there's a letter dated the 4th of October. So this is after permission has been granted. And you'll see there's a letter dated the 4th of October 2017. We specifically risk disclosure in all material from Barra McGorry considered in making his decision, and we refer to the documents mentioned in paragraph 15, all documents. The response to that is over the page 201, dated the 12th of October, and that is the final word we've had from the director on this. Thank you for your correspondence. Please be advised material requested has been considered in the light of a decision arising in the case of Tweed against the Parades Commission. It's not considered disclosure of the materials sought is necessary in order to resolve the matters fairly and justly. So a fairly curt response. In fact, perhaps in spirit, if not in decision, that submission found favour with the court below, that there had not been transparency. Can I just show the court that? If we go to the decision of the court below, it's in part 1, page 121. It's also in volume 1. But if I give the court paragraph numbers, one will be able to follow if the court is looking at it in a different place. But in the core bundle at page 121, paragraph 60. First, perhaps, counsel's strongest arguments centred around his submissions that the director had in the first phase failed to provide adequate reasons for his decisions. Secondly, he'd failed to disclose materials upon which his reasoning was based. And there's then comment about the council draws attention to the case of Nelson and subsequent rationalisation. At 62, we consider that arguably greater care could have been given by the director, setting out in some more detail in his affidavit, and indeed in the pre-action protocol response letter, the nature of his reasoning for both his suspicion and his satisfaction. We strongly urge the director to consider the need for all such care in future cases. Why, to take one example, to the letter of 10th of May, the decision letter, specifically refer to the jury issue of Bass, but the director's affidavit did not embrace such specificity. However, they go on to say that the court found that the facts speak for themselves. So, in our respectful submission, that is an erroneous approach. As we've seen in 63, the court said, well, the facts speak for themselves. The fact that the court thinks the decision was ultimately correct is no substitute for the decision maker giving adequate reasons and disclosing materials on which he based his decision. This is a procedural challenge, and the correctness of the decision is not an issue. Can I just give my Lord, it's a common position. The reference is set out in our written case. It goes back to Lord Wright's speech in GMC and Spackman. The reference is Volume 1, Tab 3, page 307, at page 324 to 325, and simply says that if a decision is procedurally unfair, the correctness of the decision is immaterial, it has to be set aside.
It's a small point, but on page 201, the letter coming back to your solicitor's request of the 4th of October 2017, referring to Tweed, I think I am right in saying that that's all about disclosure in the judicial review proceedings.
That's correct.
Is that right? And so my question was, presumably, you could have sought disclosure in the judicial review proceedings if you wanted to maintain the case that disclosure of that material was essential for a fair determination of those proceedings.
We could have had a separate application, my Lord is right.
And my
the
next
timing
question was,
didn't fit.
just to check, what was such an application made?
No.
Okay.
It was dealt with in the substantive hearing. Well, that really deals with our submissions on procedural fairness. Can I then come to the true construction of Condition 4, which is the statutory construction point of Section 1, subsection 6. So, my Lord, turning to the second issue. And, of course, this bears upon the certified question, and the approach of the respondent depends on the correct construction of Condition 4. I wonder if we can just turn up the subsection again to have a look at it. So it's 1 subsection 6. Now, what one sees immediately in the subsection is the words "to any extent," and in parentheses, whether directly or indirectly, as a result of, or in connection with, or in response to. And my Lord, a preliminary observation is those words are so sweeping as to create some ambiguity and can lead to absurd or impractical results. Taken together, those words effectively impose an unlimited reach. If we wish to discern the true intention of Parliament, we need to look at the context and surrounding circumstances in which the provision was passed. And I do want to take my lady and my lords to the explanatory notes. Much was said below, and is said by my learned friend, about the use to be made of explanatory notes. So before I actually go to them, can I just show you the full extent of the description by Lord Steyne in the Westminster City Council case when he deals with explanatory notes? Because with respect to the decision of the court below, the passage they quote is very selective and not in context of the entirety of what Lord Steyne said. It's volume 2, tab 23, page 981. And if I go to page 983, in the speech of Lord Steyne, and at paragraph 4, he sets out, in 1999, a new system was introduced, publishing the explanatory notes. He sets those out, they accompany the bill. Importantly is paragraph 5, beginning halfway down the page on 983. The question is whether in aid of the interpretation of a statute, the court may take into account the explanatory notes, and if so, to what extent. The starting point is that language in all legal texts conveys meaning according to the circumstances in which it was used. It follows that the context must always be identified and considered before the process of construction or during it. It is therefore wrong to say that the court may only resort to evidence of the contextual scene when an ambiguity has arisen. In regard to contractual interpretation, this was made clear by Lord Wilberforce. And dropping down, Lord Hoffman made crystal clear that an ambiguity need not be established before the surrounding circumstances may be taken into account. The same applies to statutory construction. And if we go over the page to page 984, still in paragraph 4, just above B, again, there is no need to establish an ambiguity before taking into account the objective circumstances to which the language relates. Applied to the subject under consideration, the result is as follows. Insofar as the explanatory notes cast light on the objective setting or the contextual scene of the statute and the mischief at which it is aimed, such materials are therefore always admissible aids to construction. They may be admitted for what logical value they have. Used for this purpose, explanatory notes will sometimes be more informative and valuable than reports of the Law Commission or advisory committees, government or green or white papers. And dropping down, between just above D, if used for this purpose, the recent reservations in dicta in the House of Lords about the use of Hansard materials in the aid of construction are not engaged. And at 6, there's matters about clear assurances. The passage at the end of 6 is the only passage quoted by the Divisional Court below for their reasoning, which obviously the appellant agrees with. But it's clear what is impermissible is to treat the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. But that does not mean that one cannot properly take into account. Obviously, there's ambiguity, and in any event, for contextual analysis, the explanatory notes.
Just on the Westminster City Council case, it's quite a long time since I've looked at it, but from memory, I thought it was just Lord Steyn who said this, and the others didn't agree. Well, they didn't agree or disagree, or do they? Have I misremembered?
I'm not sure there's much else said,
No,
but
quite.
certainly the Lord Millet agrees with Lord Hoffman, and Lord Rogers agreed with Lord Hoffman. Lord Hoffman is certainly quoted by Lord Steyn in those matters, but doesn't deal with any provisions. But our argument is, as it were, belt and braces, my lord, in that we either say that there is ambiguity, or if there are impractical or absurd results, one can resort to other materials. If I were wrong about the ambiguity, we say one can look at the explanatory notes for context.
I think it's right that none of the other members of the appellate committee referred to explanatory notes at all.
No. My Lord, can I just show you what the Minister said about the interpretation of Condition 4? We find that in the Appendix Part 1, page 250. And after that, I'll then just take, my Lord, to the explanatory notes. At 250, what the Minister said is why the fourth condition in the Act was required. And rather than lead out, can I just ask my lady and my lords just to read to the bottom of the page, and just the first line of the page on 251. It's difficult, in fact, to reconcile the statement about Al-Qaeda, because for my part, one would say that the Al-Qaeda example would fall within condition 4.
I'm a little bit unsure in my own mind how this is helping us. I wasn't sure that I'd picked up from your case that you had a distinct pepper and heart argument. As I understand it, this is the minister speaking in Parliament. That would be pure pepper and heart if it's relevant. Are you saying it is relevant for those purposes? I hadn't seen
Well,
the
my Lord,
argument.
insofar as it's ambiguous, it is a pepper and heart argument. If the words are not ambiguous.
This doesn't begin to meet the requirements for pepper and heart.
Well, my Lord, if the statute provision is ambiguous, and this is I accept it would have to be a clear statement by a promoter of the bill. What we do have, but it's probably better to take you to the explanatory notes. Can I take you to the explanatory notes, which my lords will find?
I'm so sorry, just before we move away from pepper, I just want to know, are you making a submission on pepper and heart or not? If not, that's fine.
Well, Lord,
we don't need to deal with it.
It's difficult to make a pepper and heart because it's difficult to point to
I
a clear
respectfully
statement.
agree, but that sounds as though
that's
you're
our
not
position.
making such a submission.
That's right, my Lord.
All right, thank you.
So if I could then just take, but I can take, my Lord, to the explanatory notes. Those are in Part 1, Appendix Part 1, page 210. And just by way of introduction, my lords will see that the background and summary is a heading, and under paragraph 4, it gives the explanation that the passage of the Act was an attempt to secure normalisation and to get rid of the diplock courts and for the presumption to be trial by jury. And indeed, if we drop down to paragraph 7, it says, despite the proposed jury reforms, it's not yet possible for Northern Ireland to operate entirely without the fallback of some special arrangements for a small number of exceptional cases. And of course, it is said this should only be except small number of exceptional cases. And of course, that assists when looking at the interpretation, a strict interpretation of the statute. It goes on to say that again in the penultimate sentence of paragraph 8 on page 7 on page 211. Small number of exceptional cases. And there is guidance on the specific clause we're dealing with at page 213, paragraph 22 of the explanatory notes. It says condition 4 is set out in subsection 6. This covers circumstances where the offence occurred as a result of or in connection with sectarianism, i.e., connection with religious belief or political opinion. And in particular, we'd ask the court to note the emphasis on sectarianism. The contextual setting that we have, just step back from the explanatory notes, is that only a small number of exceptional cases would be engaged. And that exceptionality informs the approach of this court, we would say, in its supervisory jurisdiction of the respondent's certificate. And condition 4 was only intended to cover circumstances where the offence occurred as a result of or in connection with sectarianism, which is political hostility. The overall approach of condition 4 was to sweep up those cases not caught by conditions 1 to 3. 1 to 3 to deal with prescribed organisations and only to Northern Ireland. Condition 4 is not limited to Northern Ireland. And the example which was given simply by pray and aid by way of forensic example is the Whitelock disturbance, which my lords have seen in the Hansard extract. So, can I just set out what our construction of the subsection is?
Well, just before you move away from the explanatory notes, might it not be said that they're not particularly helpful for construction of condition 4, because condition 4 uses explicit language, which is actually a good deal more detailed than what is the rather brief summary in this sentence in paragraph 22.
I tend to agree with my lord. My lord, it's a contextual setting. It's dealing with sectarianism. And sectarianism here is, and as I'll show you in the precise words of the section, dealing with political hostility.
Well, it's not, well, it depends on one's connotation of sectarianism. But you're not suggesting, are you, that condition 4 is confined to instances of naked sectarianism?
Lord, it informs the approach. Condition 4 is confined to political hostility. Those are the words of the section. And political hostility here is used in a shorthand way by the draftsman of the explanatory notes as sectarianism.
Well, sectarianism, in its conventional connotation, involves one section of society engaged in aggression against another. For instance, if a member of the Provisional IRA were to shoot at a British Army soldier, that wouldn't normally be described as sectarianism, would it?
No, my lord, it wouldn't. It wouldn't.
It would certainly satisfy condition 4.
My lord, yes.
Yeah. Right.
But that is one has to be careful about the limits here. It may assist with the court understanding my submissions if I set out our construction. The use of the word offence can be interpreted as conduct for ease of understanding. It uses the word offence in the subsection. An offence is comprised of acts and omissions. So conduct. So we say the conduct must have occurred or been committed owing to or because of or as a result of religious or political hostility. And the importance is that whether we use the term sectarianism or political hostility, that is engaged with the conduct. So if I give my lords an example to draw this to life by way of illustration. If D unlawfully assaults or shoots V because of D's sectarian hostility towards V, then D falls within condition 4. If in response to V's sectarian hostility to D, D unlawfully assaults or shoots V, then again he falls within condition 4. Those are obvious examples. But if D's unlawful assault or shooting of V has nothing to do with D's sectarian hostility towards V, then D does not fall within condition 4. So it's...
Well, if D shoots B, use your example, because of D's perception that B is politically hostile to D, does it fall within condition 4?
If that was the reason for committing the offence, because you're a member of the IRA, I shoot you, then it falls within condition 4.
No, I don't think I've made myself sufficiently clear. If D shoots B because D perceives that B is politically hostile to him, does that fall within condition 4?
May my lord just give me one moment? I want to be careful.
Yes, of
my
course.
lord say B or C? It's all B.
No. If the shooter shoots the victim, let's be clear, because the shooter believes that the victim of the shooting is politically hostile to the shooter, does that fall within condition 4?
Yes.
Yes, thank you.
And normally, it's D's political or sectarian hostility that will cause condition 4 to be satisfied. It could, as I've explained in that example, be the victims. But only in rare cases where neither the defendant nor the victim has any sectarian connection. But there is sectarian violence which is part of the commission of the offence, will condition 4 be satisfied. So such an example may be the offence committed within the context of a sectarian right. And in fact, that is the rare use of subsection 1, subsection 8, when neither the defendant nor the victim are party to it. Now, in the instant case, the director appears to have taken condition 4 as encompassing the fact that but for the political hostility between the Republicans and the Loyalists, no soldier would be on the streets of Northern Ireland. And that general situation is a sufficient nexus.
Oh, is that fair? The letter identifies 15 factors, and they specifically link the shooting to events nearby a short time before.
My Lord, we try to tease this out, as it were, whether the general situation is the position, which we've relied upon both in the decision letter and paragraph 10 of the affidavit. There is no specific explanation on what the suspicion is based upon. When the specific question was asked of the director in writing, does this apply to all soldiers? It's not answered. It simply said we deal with things on a case-by-case basis. So no doubt Mr. Simpson will tell us whether or not the general situation applies or not.
Well, it's clearly not going to apply to all offences that might involve soldiers.
But of course not, my Lord. We say it's a misreading here, because what is required is, for instance, the motive for the commission of the offence. If the motive for the commission of the offence was sectarianism or political hostility, then it comes within condition 4. If the motive was to prevent someone running away or resisting arrest, it's not, because there is no link. It's not part of the elements of the offence. It's not part of the conduct which is alleged against the defendant.
Well, the expressions used aren't confined to motive. It has to be as a result of, in connection with, or in response to.
Yes. But perhaps I can do better by bringing it back to the facts of this instant appeal. The Crown's case on the instant appeal, and I hope I put this fairly, is that the deceased was shot because he was acting suspiciously, failed to stop when ordered to do so by the appellant, who may have thought he was a suspected terrorist. On any view, he was shot because he failed to stop when ordered to do so. The offence was not committed because of, or as a result of, political hostility. The commission of the offence, if it occurred, so it's not accepted by the appellant at the moment, has nothing to do with sectarian violence. What one can see that is accepted in the affidavit of the director at page 9. It's page 192 of the Gore bundle. There is no suggestion the soldier was any part of any sectarian divide, nor is he involved in a prescribed organisation. Now, we have a general difficulty, as I've just outlined to my lady and my lords, as to how the director came to this, and his reasons are not clear on that. There is no reasoning in the decision letters. My lord, we understood it to be, in giving it a wide interpretation, the general approach that because the connection was because the soldier was there because of the troubles, as it were, to put it colloquially.
Which particular passage do you rely on to make that point?
Paragraph 10 of the affidavit of the director at page 192.
192, thank you.
This is really the heart of his reasoning. So if my lords dissect the paragraph, the first few lines up to namely are just a recitation of the statutory provisions. He then says, namely, in connection with a response to the political hostilities of the Provisional RA towards those believed that Northern Ireland should remain a part of. But the error we say that's fallen into here, it's got nothing to do with the commission of the offence. The commission of the offence must relate to political hostility in the commission of the offence, not in a general circumstance. So if, which is the case here, that the deceased was shot because he failed to stop, that is not committed in connection with political hostility.
I'm not sure that I'm following this. I thought that if one looks at paragraph 12, you have a whole set of factors by reference to the particular facts of this case, which amount in effect to the lifeguards had been under attack a matter of 2 days or so beforehand. They came upon the victim here who ran away. He was believed to be or suspected to be a terrorist and suspected to be armed so that they might come under attack again. So if one starts with the hostility of the Provisional IRA towards the identified category, including British troops, and the defendant believes that he might come under attack as a result of activity by the Provisional IRA, so directed, why can't it be said to be in response to that political hostility or in connection with it?
Well, our first position is that's not articulated by the director. But even if we would say that this is an isolated incident, that the reason that the deceased was shot was not because he could have just as easily been a bank robber who failed to stop. The fact that he was a member of the IRA is nothing to the point, or a suspected member of the IRA, which was in fact false, is nothing to the point when one is looking at the commission of the offence. Because the circumstances must relate to the commission of the offence, not, and in this particular instance, that is the reason why he was shot, which was because he failed to stop.
Well, the difficulty with that argument, I think, is implicit in it, is that you can isolate the circumstance that he failed to stop from all of the surrounding issues. And the reason that someone in 1974 in Northern Ireland might come under fire from the British Army isn't simply, surely, because he failed to stop. In the rules of engagement, as used to be called the yellow card, make it explicitly clear the circumstances in which it is permissible to shoot. And therefore, as my Lord Sales points out to you, you can't fasten on paragraph 10, isolate that entirely from the context. You've got to take into account what the director says in paragraph 12.
Well, my Lord, it's difficult from the reasoning to articulate how he deals with it. He simply says, in part, the following factors were relevant in my decision. Now, he doesn't explain why they were relevant, because we say this is 2 days later. It's a different incident. The appellant was not, it's not suggested in here the appellant was part of the incident. It deals with other members of the lifeguards. I mean, all these are matters which no representations were made, no proper reasoning was given, and it's not articulated how he came to his suspicion. And this is, we would respectfully say, a different incident. If one joins those all together, and I think at the heart of this is, of course, it's a matter of what the facts are that bring it to bear. Because if one ignores paragraph 12 and one simply says, a soldier in Northern Ireland shoots someone who fails to stop, who he suspects as being a member of the IRA, we would respectfully say that that is not enough, and that's the certified question. That is, because that on its own is not enough. That does not make the sufficient nexus. It may be there is an additional element to the nexus here, but the reasoning as we understood it before the divisional, and if we turn up I'll always have the certified question, it doesn't have those additional factors in it. So the certified question, it's in the statement of facts and issues.
One aspect of this that we have to bear in mind is that the DPP doesn't have to be satisfied that there is a nexus. He doesn't have to have reached any concluded view at all about anything. He simply has to have a suspicion that there's a nexus.
I agree. But it's difficult for the court to scrutinise that decision without understanding the basis on which he put those reasons. And it's difficult without it being articulated why there was such a suspicion. Because if we look at I was just going to take my lord and my lady to the certified question. The stacks.
The certified question, Mr. Lewis, is a way of bringing the issue before the court.
Yes.
But we can't really be bound by the very, very brief description of the circumstances in the question, can we?
Well, my lord is obviously right in that the certified question creates the jurisdiction for the matter to come before the court, and the court could answer the certified question even in a way which the applicant submits it should be answered, and come to a different opinion on the appeal itself. But the certified question itself is, we would respectfully say, at least a freestanding question, unless your lordships and my lady were to answer it with some form of amendment. I'm not sure if I've answered my lord's question.
The purpose of bringing the matter before the court is for the court to address the particular evidence in this case.
I accept that.
Mr. Lewis, in the submission you just made, which I follow, that if a soldier just shoots someone who he believed to be a member of the IRA, you said that would not be sufficient, there wouldn't be a sufficient nexus. Now, that way of putting it suggests to me that you accept that the question of nexus, or the closeness of the connection between the political hostility of group to group and the events of the offence, is a material consideration to be taken into account.
Well, I think I have to accept that, my lord.
Yes.
I mean, it would be...
So if you could assist us as to why paragraph 12 are not to be regarded as indications by the DPP of those matters which he took into account as establishing that there was a sufficient nexus going beyond the simple case of a shooting in the street with nothing more.
Could I answer it in this way? In that, until we know how he took into account paragraph 12, it's not possible to answer that. Because in our respectful submission, it would be wrong simply to say, well, or provide the reasoning, the lacuna in reasoning, in the decision letter or the affidavit, in order to create that sufficient nexus. We just don't know. So we're reviewing his decision on his material.
Yes, thank you.
So my Lord, I think my Lords have my submissions on condition 4, how we put it. I've just dealt with the certified question. Could I just finally turn and good progress to the errors of law which we set out are in our case? They're towards the end of our written case. Page 64, paragraph 98. And can I just deal these relatively briefly in a summary of the errors of law we say have arisen, this being a public law challenge. He did say, as my lady and my lords have seen, that section 1.6 should be broadly interpreted. We say that's an error of law. Indeed, there's the authority for that is in fact direct. If we went to page 172 of, I'm sorry, it's I think it's volume 1, page, sorry. It's page 283, paragraph 32. I just can't read my own writing. It's in Arthur's case. I just simply draw that to the court's attention. Paragraph 32. That section 1 of the 2007 Act should be strictly construed. Do my lords see that? It chimes with the other cases we've set out in our written submissions, which deal with, from Aronson to Tuck and Priestley, as this is effectively dealing with criminal procedure or a criminal statute, it should be strictly construed.
And it's also
I need
impinging on a common law right.
Exactly. Exactly.
The difficulty is the width of the language used in the provision itself.
I agree. However, that's not how the director put it. He didn't say that it was the width of the language. He said it should be broadly interpreted. I've dealt, I'm just running down at paragraph 98.2, condition 4 applied to the facts of the case. The third point we made is he misdirected himself as the requirement to be satisfied there was a risk of the administration of justice might be impaired if the trial were to be conducted with a jury. And we just don't have any information on this. There is some matters which do not follow in the decision letter that he obviously took into an irrelevant consideration. But he simply says bias without more, and doesn't deal with the matters which I showed my lady and my lords earlier in the Attorney General guidelines and in the section 13 of the 2007 Act. Can I also then just briefly take my lord to our paragraph 103. If this is predicated on the submission that it was, in fact, jury tampering which arose because he was talking about sequestration and screening, which are matters which go to jury tampering. So if, because it's not clear from his decision letter, if he was actually talking about jury tampering, he misdirected himself on the way in which section 1.2b would flow, because the factors there do not flow from, for instance, paragraph 12 of the director's affidavit. My My Lord has our submissions on that. We say the breach of procedural fairness is a very strong point in this appeal. And unless there are any other matters that my lords would like to inquire upon, those would be our submissions, and we further simply rely upon our written case.
Thank you very much indeed, Mr. Lewis. Mr. Turkington, is there anything you wish to add?
No, thank you, my lady, my lords.
Mr. Simpson.
My lady, could I make, first of all, a general point about the object of sections 1 to 9 of the Act. The object is to generate fair trials in Northern Ireland. If we need any basis for that, it can be found in the explanatory notes, although I'm conscious of what the court has said about the explanatory notes. And I'm also conscious that in the Westminster City Council case, Lord Staines's remarks were technically, I think, obiter, because in paragraph 1 he'd agreed with Lord Hoffman's decision and then goes on to make the point about the explanatory notes. But insofar as the court might look at the explanatory notes, in core bundle, page 211, one finds the basis for the submission I've just made to the court. At the top of page, my learned friend referred to paragraph 7 at the bottom of page 210, and at the top of the page he read a little bit of that, but if you take the 5 lines at the top of page 211, this means that the presumption will be for jury trial in all cases, while the small number of exceptional cases requiring non-jury trial will still be able to be treated appropriately. Such a system is necessary to ensure that trials continue to be fair in Northern Ireland and that the quality of justice remains high. Top of page 211. That's what the sections of the Act set out to achieve. And it's right to say that risks to a fair trial in respect of juries arise from juror intimidation, tampering of juries, but also perverse verdicts because of partisan jurors. And there are a number of places I'd like the court to look at, if I may, just to, I hope, make that point good. If the court turns to Authorities Volume 2, tab 30, which is the consultation document. I'll deal with these quickly because they really only set the scene, my lords, my lady, but the document begins under tab 30 at page 1193, and if you turn to paragraph 2.1 of the document, which is on page 1197, top of the page, the court will see the Diplock court system dates back to 1973, and then third line, it highlighted the danger of perverse acquittals because of partisan jurors and intimidation of jurors. These dangers were still assessed as continuing when the system was reviewed by government in 2000. And if you turn over the couple of pages to page 1200 to paragraph 3.13, at the bottom of the page, under the rubric of abolition of peremptory challenges, the consultation document says, although it is difficult to obtain specific evidence in this regard, it is widely perceived that the polarised nature of society within Northern Ireland is such that some jurors may be unduly influenced by their political and religious backgrounds in reaching a verdict. If you just stay in that bundle at page 1213, one gets Lord Carlisle's letter. At the bottom of page 1213, Lordships and Ladyship will see paragraph 13. The Diplock Review of 2000 identified 3 factors as material as to whether a jury trial was possible, and the second bullet point over the page is risk of perverse verdicts. And Lord Carlisle says, my assessment is that all 3 risk factors have reduced significantly since 2000, but that they still exist and are enhanced in Northern Ireland as compared with other parts of the United Kingdom. That we had mentioned in our printed case the first instant judgment of Mr. Justice Stevens, as he then was, in the Jordan Inquest Judicial Review. It hasn't made its way into the bundle of authorities, but could I ask the court to receive 2 pages of it, and we provide a copy in due course. Could I ask? Just 2 pages of the judgment which are relevant to the remarks that I'm making at the moment, my lords and my lady, and they're available to the court. But an electronic copy will be made available in due course.
Yes, we've been given another judgment in the same proceedings. There are quite a
In
lot
the
of
Court of
judgments.
Appeal, yes.
Yes, well, I think my Lord is referring to yet another Jordan judgment.
Oh, yes.
Yes.
Well, I think
Coming
there's
from this court.
something like 26 judicial reviews in the Jordan case, so everybody's been in one of them somewhere along the line. It's the paragraphs in the Jordan first instance judgment are that I'm asking you to look at is paragraphs 238 to 242. I'm making them available to the court. The citation is 2014 NIQB 11, and it's dealing with the risk of perverse verdicts in criminal trials, is the heading of the passages.
Thank you, Derek.
Some of this appears in other material, but it's a useful place to see it all. Paragraph 238, a consultation process was conducted by the Northern Ireland Office in August 2006 on the replacement arrangements for the Diplock court system. We've just seen that document. This consultation was in advance of what became the 2007 Act. The consultation paper set out the background to jury reform. It referred to perverse acquittals because of, for instance, partisan jurors, to the close-knit communities in which people live in Northern Ireland, and to the perception that the polarised nature of society as such, that jurors may be unduly influenced by their political and religious backgrounds. And then it refers to Lord Carlisle's letter. 239, the view of the Northern Ireland Office and of Lord Carlisle in 2006 that there was an enhanced risk of perverse jury verdicts in Northern Ireland was reflected in the Attorney General's guidelines on jury checks on the use of the prosecution of standby, issued on 1st of August 2007. It stated that in certain cases it was in the interest of both justice and the public that there should be further safeguards against the possibility of bias, and in such cases checks which go beyond the investigation of criminal records may be necessary. It identified typical aspects of the case which may make it desirable to seek extra precautions, as including that in both security, as this is, and terrorist cases, the danger that a juror's political beliefs are so biased as to go beyond normally reflecting the broad spectrum of views and interests in the community to reflect the extreme views of a sectarian interest or pressure group to a degree which might interfere with his fair assessment of the facts of the case or lead him to exert improper pressure on his fellow jury. And then my Lord Kerr, as Lord Chief Justice, gave a judgment in McParland, which is referred to as well in our printed case. My Lord Kerr said, 37, the existence of the risks identified by the jury's subgroup of partisan juries and of perverse jury verdicts has not been seriously disputed by most commentators, although there's been acute disagreement about the measures needed to deal with the risk. So whenever may be the position in other jurisdictions, it is recognised that in some cases in Northern Ireland, that is in security and terrorist cases, there is a real possibility of perverse jury verdicts. Accordingly, the fact that in England and Wales and the Republic of Ireland, a jury must be summoned in inquests where a death is caused by a police officer only illustrates the difference between those jurisdictions and Northern Ireland. The real possibility of perverse verdicts that has been identified is a perverse verdict either for or against the security services or for or against those involved in terrorist activities. Furthermore, it has also been identified that the community divisions in our society are such that the exact nature of the perverse verdict is influenced by the geographical location of an inquest. So there is a clear indication both in Jordan and in McParland of the risk of perverse verdicts. And then if the court would be so good as to go to Authorities Volume 1,
Can I just check? That's the Jordan's application that's referred to in the DPP's affidavit?
Yes, he refers both to Jordan in the first instance and in the Court of Appeal, and he also refers to McParland.
Yes. This is, I'm so sorry, this is...
That is the first instance, yes.
Mr. Justice Stevens.
Mr. Justice Stevens, as he then was, yes. And then if I was asking the court to turn to the Court of Appeal in Jordan, which is to be found at Authorities Volume 1, Tab 6. And the starting point when they're dealing with this aspect of the case is paragraph 70 of the judgment, which the court will find at 399 of the authorities bundle, and memory stick number is the same. And just to see where we are, this is the jury issue that's being dealt with by the Court of Appeal, as appears from the top part of the page. And then over on page 400, the court will see at paragraph 75 a discussion of the judge's decision. And then, if I may ask the court to turn to paragraph 84 at the bottom of page 402, where the Court of Appeal reaches its decisions on this issue. On the other hand, it would be idle to ignore the problems both of jury intimidation and perverse verdicts in Northern Ireland. Mr MacDonald, who was counsel for Jordan, correctly adverted to this strain coursing through a presence of scheduled criminal cases in Northern Ireland following the Diplock report of 1972, and then there's a reference to my Lord Kerr's judgment in McParland. The risk, albeit reduced, exists to the present time. And then there's some more discussion about it, but if I could ask you then to turn over the page to paragraph 90 on page 404, where the Court of Appeal went on to say, however, in deciding whether it is likely to be beyond the reach of a jury to decide such matters impartially, doubtless coroners may wish to take account of such factors as there are formidable difficulties in being satisfied that the insidious nature of bias has been removed in security and terrorist-type cases. It is necessary to confront directly the need to ensure that jury verdicts emerge unconstrained by tribal loyalties. A coroner must be satisfied there will be a sensitively constructed distance between prejudice and justice. The existence of a real risk of a biased juror or jury will outweigh any other factor. That is the background to what we respectfully say is the object of the sections, and that is taken up in the judgment under appeal, which I needn't take you to now, but you will find it in the core bundle, page 120 and paragraph 57. And it's our respectful submission that in order to achieve the objective of generating fair trials, the wording of the Act has been very widely framed. I use the word very advisedly because it's more widely framed than I've not been able to find something that is as widely framed in this type of context. And it's widely framed also in the context of the fact that there have been prosecutions of soldiers in the past in the Diplock courts. So it's not as if prosecution of soldiers wouldn't have been in the mind of those producing the legislation. So our principal submission to this court is that if Condition 4 is held not to apply to the trial of the appellant, then in a situation where historically and into the present there has been and is a recognised risk of a perverse verdict from a jury in this type of case, i.e. involving a soldier, the statute will not operate to avoid such a mischief. And in our respectful submission, that ought not to be the case. And this is in circumstances where the appellant's own counsel conceded in the divisional court that if the incident had occurred in the immediate aftermath of the shooting event that took place a couple of days previously, Condition 4 would clearly have been invoked. So in our respectful submission, Condition 4 will apply to this. Could I ask you then to turn to the section which was handed up by my learned friend to the court earlier, and just look at the way the matter is worded. Section 1, subsection 2 provides for the issue of certificate that the trial is to be conducted without a jury if, and then A, he suspects that any of the following conditions is met, and I respectfully submit that that is a low bar, and that he is satisfied that in view of this, that is, in view of the suspicion, there is a risk that the administration of justice might be impaired if the trial were to be conducted with a jury. And Condition 4, in our respectful submission, is extremely widely drafted. The offence or any of the offences was committed. So that's the shooting, the attempted murder, was committed to any extent, whether directly or indirectly, as a result of, in connection with, or in response to religious or political hostility of one person or group of persons towards another person or group of persons. Subsection 7 is important as well because it widely defines religious or political hostility as hostility based to any extent on religious belief or political opinion, or supposed religious belief or political opinion, or the absence or supposed absence of any particular religious belief or political opinion. So we say also, my Lord and my Lady, that is extremely widely framed. And then, importantly, in subsection 8, it says, in subsection 6, the references to persons and groups of persons need not include a reference to the defendant or to any victim. So it matters not that in this case, Mr. Cunningham, the deceased, was not a member of the IRA, or that the appellant was a soldier in the British Army. And it's against that background, my Lords and my Lady, that we say that suspects, the word which is used, is not subject to the adjective reasonable. My learned friend says, well, that is nothing to the point. But we respectfully rely on the speech of Lord Roskill in McKee and the Chief Constable for Northern Ireland, which can be found in the Authorities Bundle 3, tab 41, begins at page 1421. The passage we respectfully rely on to answer my learned friend's point is on page 1425. What the absence of reasonably before the word suspects means is this. It's in the page just below letter C. The full paragraph begins just before letter C. In conclusion, I would mention two other matters. First, I respectfully agree with all the learned judges below that on the true construction of the statute, the powers of arrest under section 11 are not qualified by any words of reasonableness. The suspicion has to be honestly held, but it need not be a reasonable suspicion as well. And so, as long as the suspicion is honestly held, it's not qualified by the word reasonable. And that's, in our respectful submission, an example of the bar being set at a very low level.
Can we necessarily transfer that from a statute concerned with the power of arrest into the prison context?
I think in the sense that it uses the word suspicion. Suspicion is a term of art, really, in those circumstances. To that extent, it's less obvious than if it would be in a different context. I suspect that I understand you have to have a reasonable suspicion of arrest, but that's only an honestly held suspicion. But there's no reason why that description of suspicion cannot be used when examining what suspicion is used, the way suspicion is used in this Act. The word suspicion has been deliberately chosen. The word reasonable was deliberately left out of the definition in the statute. And we respectfully say that insofar as my learned friend says it's nothing to the point, one's entitled to rely on Lord Roskill's view.
It may be relevant that Section 7 restricts challenges to the grounds of dishonesty, bad faith, or other exceptional circumstances.
Yes, I'm going to come to other
So if suspicion meant reasonable suspicion, then evidently a challenge could lie on a wider basis.
On a wider basis, yes. And that's why I respectfully do rely on Lord Roskill. I accept Lord Jones's point, but there is no qualification of suspicion, and Lord Roskill explains what that means. It means as long as it's honestly held, it is appropriate that it's not a reasonable suspicion.
Thank you.
That's the level to which I rely on it. We've set out in our case, the case of Hussein against Chung from Kam. I'm not sure that I need to take to it. It's just another definition of suspicion in its ordinary meaning is a state of conjecture or surmise where proof is lacking and can take into account matters which could not form a part of a prima facie case. The court will find that in Authorities Volume 3, tab 38, at pages 1385 and 1386. I don't think I need to take you to that.
I'm so sorry, could you give the page references again?
I'm sorry, it's Authorities Volume 3, tab 38, yes. And the pages are 1385. In the report, that is 948B, and 1386, which is 949B to C in the report itself. It might be worthwhile just looking at it briefly. So it's tab 38, 1385. And just at letter B of the report, you'll see the Privy Council saying, suspicion in its ordinary meaning is a state of conjecture or surmise where proof is lacking. I suspect, but I cannot prove. Suspicion arises at or near the starting point of an investigation of which the obtaining of prima facie proof is the end. And the other passage is over the page. Letter B, suspicion, just at the end of the line, suspicion can take into account matters that could not be put in evidence at all. There's a discussion about the relevance of previous convictions in the judgment of Lord Wright. Suspicion can take into account also matters which, though admissible, could not form part of a prima facie case. So that's the level, we respectfully say, at which the statute casts the state of mind that the director is required to have. And we respectfully say that it's set at a modest level for the particular purpose which we have identified, and that is to generate fair trials in Northern Ireland and to ensure that the quality of justice remains high. The relevant factors which the director says he had in mind when arriving at the suspicion in 1.2a are those which are set out in the letter and in the affidavit. There are, I think, 15 factors which relate to the events that occurred in the immediate run up to the shooting. But I think it's important in our respectful submission to look at what actually those factors were. And the court will find them at the Court Bundle 192. It's easy to say that there are 15 of them and glide over them, but they are important factors because they, in the light of the issue about perverse verdicts, they're important factors because they set the particular scene in this case. And you will see at paragraph 12.1, in 1974 there was a sustained campaign of violence undertaken by members of the prescribed organisation, the Provisional IRA. This campaign involved, inter alia, attacks on security forces which inevitably included members of the British Army. Attacks were mounted against persons believed to be members of unlawful organisations on the Loyalist side. Attacks were mounted by use of weapons and explosives. The Lifeguards, a unit of the British Army, was stationed in the area in question. In the first 2 weeks of June 1974, some 38% of the shooting incidents in the Lifeguards group occurred in the area of English. One of these attacks resulted in the death of a Lifeguards soldier. 2 days before the fatal shooting, members of the Lifeguards, under the command of the appellant, came upon a group of men loading material into a vehicle. Those members of the Lifeguards were involved in a firefight with those men after the men had been challenged. Some of the men were apprehended, but, and it's important, but, my lords and my ladies, some escaped. As a follow-up to that firefight, arms and explosives were seized from the vehicle. The group of men was suspected to be made up of members of the Provisional IRA. On the day of the fatal shooting, a patrol of the Lifeguards came across a person some 3.5 miles away from the scene of the firefight. That person was the deceased, and he ran away when confronted by the soldiers. He was suspected of being a terrorist, and there was a suspicion that he may have been armed. He was called upon to stop, but did not. And that sets the context of the shooting. So that one goes back to the statute in our respectful submission to see what the statute says about that. And what the statute says about it is that the offence was committed to any extent, whether directly or indirectly, as a result of, in connection with, or in response to the hostility. And in our respectful submission, it would be an affront to the wording of the statute and the policy behind the statute to suggest that where soldiers who have been involved in a firefight a couple of days before come across a man in the same situation acting suspiciously and a shot is fired by the soldiers, in our respectful submission, that clearly falls within the wide ambit of Condition 4. And bearing in mind that the state of mind of the director is suspicion, not more than that. In our respective submission, it's quite clear that the events in this case fall within the ambit of Condition 4. I'm not sure whether there is any merit in taking you to the definition of political opinion in cases that we've cited, but I'm content to do so. If you want to have a quick look at, for example, Authorities Volume 3, tab 40, in a case in Northern Ireland Court of Appeal in 1994, tab 40, page 1403, where the issue of what political opinion meant was discussed, and if the court turns to page 1417 in the report, letter J, just below letter H, there can be no difficulty as to the meaning of the word opinion and none as to the word political. When they come together in the phrase political opinion, it means, in broad terms and without attempting any exhaustive definition, an opinion relating to the policy of government and matters touching the government of the state. And then there's a definition from the shorter Oxford Dictionary at the top of page 1418 of belonging or pertaining to the state, its government or policy, public, civil, of or pertaining to the science or art of government. And then over the page at page 1419, letter A. However, one does not have to go so far as to seek the idea or conception of political opinion. It is, as I have stated, a phrase in everyday use and easily understood, and although it has not been defined in the Act, and there is no provision in the Act to suggest or speak of a meaning other than its ordinary meaning, and we respectfully rely on that. I don't think it can really be argued that the activities of the Provisional IRA during the Troubles are anything other than political hostility. And ultimately, Section 1.2b then is the conjunctive part of the basis for the Director issuing his certificate. He has to be satisfied that in view of the suspicion, there is a risk that the administration of justice might be impaired if the trial were to be conducted with a jury. Impaired in its ordinary meaning means reduce or weaken in quality. We respectfully say that it's important that neither the word impaired nor the word risk is qualified in any way. For example, by the use of the word substantial or substantially. The test is might be, not will be. If it had been a real risk, then it would have had to have been objectively verified or objectively well-founded, which is the decision in this court in Officer L. But it is not a real risk that's being looked for in that case, merely a risk that the administration of justice might be impaired. And in our respective submission, it's clear from the correspondence from the Director and his affidavit that the issue of jury bias was relevant to his consideration. Dealt with what is said in Jordan about the matter, both at first instance and on appeal.
And is Mr. Lewis right in well, he covered both possible aspects, but he was inviting us to proceed on the footing that the real problem here, perceived by the DPP, was jury bias rather than intimidation of jurors.
This is jury bias.
Yes,
This is jury. I accept what he says about the letter, but this is clearly a jury bias case. There's no issue of jury tampering or intimidation in this case that the Director was considering. And it's jury bias arising out of the fact that it's the trial of a British soldier in the circumstances which are set out in his letter and the history of perverse verdicts arising out of that. If it is any part of the appellant's contention, I'm not sure now it is, although it may have been earlier, that no consideration to the risk of a perverse verdict should have been given, we reject that. This is clearly a case where if there is a risk of a perverse verdict, the Director has to act. It, by its very nature, would impair the administration of justice. And we respectfully say that it would have been wholly unreasonable for the Director in making a decision whether or not to issue a certificate to ignore the risk of a perverse verdict. The divisional court below referred to the experience of the Director and his long history of being involved in criminal cases in his previous life as being a relevant matter, and we respectfully say that that is something that can be taken into consideration because this was an evaluative conclusion calling for personal judgment which the court will see from paragraph 32 of the Arthur's case. That's Authorities Bundle, tab 1 at page 284.
Is it still the position in Northern Ireland, as it was under antecedent emergency legislation, that a judge sitting alone to try a case such as this must give a reasoned judgment?
Yes, my lord.
And is there still an automatic right of appeal in that judgment? Yeah.
That is top of page 284. The court deals with, in Arthur's, with the suspicion, and it says, if that suspicion is formed, the director must reach an evaluative conclusion, whether in view of that suspicion there is a risk that the administration of justice might be impaired if the trial were to be conducted with a jury. The tests of suspicion and risk to justice are set at a modest level. They are tests to be considered by the director and call for a personal judgment reached by him in the light of the information available to him. So that's the point that I was making in respect of that. My lords and my lady. So we respectfully say then that the bar is set at a low level because of the use of the word suspicion without the accompanying adjective, such as reasonable, the use of the word risk without any accompanying adjective, and the use of the word might. And condition 4 is extremely widely drafted with its use of the expression to any extent, whether directly or indirectly, as a result of, in connection with, or in response to. Lords, my lady, I'd like to move now to the effect of Section 7 on a challenge to the decision. If I may. First point we wish to make is that it is not argued, and could not now be argued after Schuker, that Article 6 of the Convention is engaged. Our principal submission is that following Schuker and Arthur's, the decision of the director is justiciable, i.e. it is susceptible to judicial review, but that any judicial scrutiny should be at the least intrusive end of the spectrum. The statute itself provides that the challenge should only be in very limited circumstances, dishonesty, bad faith, and exceptional circumstances, including, in particular, exceptional circumstances relating to lack of jurisdiction or error of law. And we respectfully say that, as the Divisional Court said, Section 7 is inspired or informed by decisions such as Kebeline, Corner House, and Schuker and Arthur's. And if I may take the court to Schuker, first of all, which is in Authorities Volume 1, tab 16. This was a challenge to the Attorney General, the then Attorney General's decision not to deschedule, was the vernacular term, deschedule an offence. And there were 3 challenges. One was to the justiciability, and the court held that at the end of the day it was justiciable. And if the court turns to page 729 of the Authorities Bundle, Kerr said, paragraph 17, it is therefore clear that in certain situations a decision which is subject to judicial review generally may be exempt from certain grounds of challenge on the ground that the scope of challenge, or that the scope of the challenge under some of the conventional judicial review grounds would have to be modified or adjusted in order to reflect the specific nature of the decision attacked. And then your Lordship referred to Lord Staine's remarks, which we've already looked at. And then if we go over on page to 731, para 21, just to deal with one point at the bottom of paragraph 21, the last 4 lines. It is not necessary to reach a firm conclusion on this question, however, and we leave for an appropriate occasion the decision whether the non-adjudicatory aspect of the attorney's decision renders it less suitable for judicial review. So in our respectful submission, relying on that, the decision of the director is a prosecutorial decision, not an adjudicatory decision, as my learned friend says, and we rely on my Lord Kerr's view of the slightly opposite.
I don't know a final view on it, but I think what Mr. Lewis says is that the director's decision partakes of an adjudication because he has to evaluate the evidence, he has to weigh it up on either side, and therefore is at least quasi-judicial.
Not sure, my Lord, with respect that he has to make a evaluation of evidence on either side. He is presented with the circumstances of the case, as it were, and has to decide whether he forms a suspicion that the test is met. But it's only that, my Lord. That's not an adjudication, forming a suspicion, because he doesn't actually come to a decision about whether it's right or wrong. He merely suspects that something is the situation. And in our respectful submission, that is wholly different from something that may be described as adjudicatory. And in the Attorney General's case in Sugar, what he had to decide was whether or not it was connected with the emergency, not whether he suspected it was connected with the emergency. So it's a wholly different. He had to make, if there is any distinction between the director and the Attorney General, it's that distinction. The attorney was making a decision that it wasn't connected with the emergency, or was. The director is merely forming a suspicion. And in our respective submission, we still rely on your Lordship's view that it was non-adjudicatory in respect of the Attorney General, and we certainly say that it's non-adjudicatory in this case. The paragraph 23 of the same case, the cases where it has been held that judicial review will not lie to challenge the decision of prosecuting authorities have been essentially pragmatic in their reasoning. I'm going to come back to that, my Lords. In the present case, many of the reasons advanced by the respondent that judicial review should not be available to challenge the decision of the Attorney General are likewise pragmatic. And then over the page, paragraph 25, again, the approach here is pragmatic. It was also dictated, of course, by the special circumstances that arise in cases involving the investigation of deaths and Article 2. What the various cases that deal with the reviewability of prosecutors' decisions have in common is an approach to the question that is firmly based on the practical implications of permitting judicial review of the decisions, whether it is a decision not to prosecute or a decision to withhold reasons. Ultimately, therefore, the question whether the Attorney General should be subject to judicial review in respective decisions about descheduling must be answered in a way that takes account of the particular features of this process of decision-making. We have concluded that it is not a process which is suitable for the full panoply of judicial review superintendents. In particular, we do not consider that the decision is amenable to review on the basis that it failed to comply with the requirements of procedural fairness. The exercise involved in deciding whether offences should be descheduled is in some respect akin to the decision whether to prosecute. And 2 or 3 lines down, the last 3 lines of the page. This is par excellence a procedure in which the courts should be reluctant to intrude. It is, moreover, a task that has been entrusted by Parliament to the Attorney General. And while this will not in all circumstances render judicial review impermissible, it signifies a further reason for reticence. Moving on to a slightly different point, if that's...
Well, if this is a convenient moment, then we will hear you further at 2 o'clock.